Attorney General of the Federation inaugurates Stakeholders Committee on Prison Congestion. Chief Justice of Nigeria warns judicial officers on corruption. Many thanks for joining us on Judiciary Watch. Our discuss today will center on the jurisdictional power of the Economic Community of West African States Community Court of Justice, CCJ, on human rights abuses.
And at the end of the day, we believe that this is a tremendous improvement towards economic growth and development, because citizens now know that they can move around, not just through the air, through the land, through the sea, and then they are protected whichever means of movement they prefer.
UCHENNA ALISON OJIABO, Esquire of the Rexon Vault Consultants and Legal Practitioners, is our guest. Please don't go away.
Keep watching Judiciary Watch for deep knowledge of the law,
issues bordering on our collective and individual fundamental rights,
for knowing the correct perspective of the law,
issues of governance.
You just watch Judiciary Watch,
because there's no program that is like
it. In a bid to curb the excesses of prison congestion and the domestication of the non-custodian sentence, the federal government has inaugurated a stakeholders committee to oversee the implementation of the Federal Executive Council's directive to fast-track decongestion of prisons. Inaugurating the committee in Abuja on Tuesday, Attorney General of the Federation and Minister of Justice Abubakar Malami said that the committee should make recommendations that will lead to the primary mandate of prisons, which is reformation.
There is no gainsaying that the facilities in Nigerian prisons are vastly overcrowded with inmates, and the environment is mostly not conducive. It is in this light that the Federal Executive Council directed the Ministry of Justice to synergize with relevant MDAs in order to fast-track the decongestion of prisons. Responding to the directives on Tuesday, Attorney General of the Federation and Minister of Justice Abubakar Malami inaugurated a stakeholders committee headed by the Honorable Chief Judge of the High Court of the Federal Capital Territory, Justice Ishaq Bello.
In review of the draft roadmap, it is expected, Mr. Chairman, that you will take advantage of your wealth of experience, the area policy reforms that has been made on the subject matter, reforms in other jurisdictions for adoption, and come up with a possible roadmap to guide our reforms for the future. At this juncture, Mr. Chairman, ladies and gentlemen, I would like to assure you of my absolute commitment to ensuring the success of the program with guest prisons. We are open for collaboration with all stakeholders, including development partners and other organizations, to improve the state of our prisons.
Reacting to the mandate given to them, Justice Bello called on President Muhammadu Buhari to bring the issue of non-custodian sentencing at the Council of State meeting in order for state governors to fully domesticate the Administration of Criminal Justice Act 2015. Other members of the committee include the Comptroller General of Prisons, Deputy Registrar of Supreme Court, the Nigerian Police, amongst others. The committee is expected to create a new generation of prisons and better model of prison management that will emphasize humaneness and efficiency.
Chief Justice of Nigeria Walter Onogen says that stiff disciplinary measures will be taken against both prosecution and defense counsels who deploy unethical antics that may result in delay at the hearing and determination of corruption cases. Justice Onogen made this disclosure while formally inaugurating the Corruption and Other Financial Crimes Cases Trial Monitoring Committee in Abuja.
It could be recalled that at the beginning of the new legal year of the Apex Court, the CJN Walter Onogen reiterated his commitment to fighting corruption within the nation's judiciary.
As the chairman, I'm particularly happy with the committee of the committee.
Marrying words with action, Justice Onuoken inaugurated the Corruption and Other Financial Crimes Cases Trials and Monitoring Committee, COTRICOM. According to the CJN, it is a move meant to protect the dignity and integrity of the nation's judicial system. The mandate of the committee, among others, is to propose directions to the CJN for consideration and approval in order to complement the Administration of Criminal Justice Act, as well as serve as a guide to all applicable rules in all courts designated for corruption cases.
I will therefore implore you to come up with strategies that will help eliminate delays and its attendant effects on the speedy disposal of corruption cases. The committee is expected to, among other things, propose a practice direction for my consideration and approval in order to complement the Administration of Criminal Justice Act and serve as a guide to as well as applicable rules in all courts designated for corruption cases.
The committee was initially billed to be headed by His Lordship Justice Ayo Salami, but rejected the position for personal reasons. Justice Suleiman Galadima retired is, however, head of the committee.
From this glimmering of ideas coming from the experience of my members, we can only assure this Honorable CJN that we can deliver our mandate. Only give us the tools and the encouragement. And that's all we want from you, CJN.
The CJN warned lawyers to desist from intentional delay of corruption cases will face stiff penalties.
It is time for a short break. Please stay tuned for Judiciary Watch Discuss.
You just watch Judiciary Watch.
Because it's no program that is like
this. At the resumption of the 2017-2018 new legal year, the Ecowas Community Court of Justice reiterated its commitment to both regional and international arbitration, especially on human rights jurisdiction. Our focus today is on a judgment delivered by the Community Court of Justice in the matter concerning a Nigerian whose right was violated at the border between Nigeria and Benin Republic. This will come to you after a brief insight on the Community Court of Justice in our background report.
The Ecowas Community Court of Justice is a principal legal organ of the Ecowas community that plays a crucial role in the integration process of the West African sub-region. It has the exclusive responsibility of interpreting and applying the revised treaty, the protocols and conventions, and all other subsidiary legal instruments of the Ecowas. Although Ecowas was founded in 1975 by the Treaty of Lagos, the Court of Justice was not created until the adoption of the Protocol on the Community Court of Justice (CCJ) in 1991. The protocol was amended twice, once in 2005 and once in 2006. Notably, the 2005 supplementary protocol expanded the court's jurisdiction to include human rights claims by individuals.
You just watch Judiciary Watch.
because it's no program that is like it.
Today we'll be having a special discuss, and we have in focus the economic community of West African states, particularly the Community Court of Justice, which we all know is a competent court of jurisdiction within the Ecowas sub-region. And from time immemorial, the Community Court of Justice has looked at areas of human rights abuses and preferred solutions, or rather rendered judgments in these areas. We're going to be meeting with a lawyer who has a real-life experience in the Community Court of Justice. She's no other person than UCHENNA OJIABO of Rexonval's Consultants and Legal Practitioners. Thank you, ma'am, for coming on this episode of Judiciary Watch.
It's my pleasure. You're welcome.
Okay. So tell us about the Community Court of Justice, particularly the jurisdiction of the court and its organization.
Okay. The Community Court of Justice is one of the institutions of the Ecowas community. It is created under Article 6, Sub-Article 1, Sub-E of the Revised Treaty of Ecowas. And then its jurisdiction was earlier on subsumed in Article 9, and then again it was later on amended and expanded in Article 15 of the protocol amending the treaty as it pertains to the Community Court of Justice.
Okay.
And then in this amendment was the jurisdiction of the court expanded to also include human rights.
Okay.
And so by that amendment, individuals and corporations can now approach the courts to ventilate their anger and also seek for redress for abuses of their rights as may have, been perpetrated by member states.
Okay. So in essence, it's geographical jurisdiction by the word ECOWAS, Economic Community of West African States. It just covers
the West African sub-region. Of course, ECOWAS is a union of about 15 countries who are, of course, countries located within the geographical region of the western part of Africa. Okay, and so the court has its headquarters in Abuja, and so the member states who have signed, ratified, and deposited the instrument, which is the ECOWAS Treaty, are naturally members, and they also signed the treaty.
Okay.
Yes, as it pertains to the courts.
Okay. So what are the constituency documents that make up the Community Court of Justice?
Okay, you have the revised treaty of ECOWAS, you have the Court of Calls in its jurisdiction as it relates to human rights, applies the African Charter on Human and People's Rights, the right act subsumed or rather contained in the African Charter of Human and People's Rights. And then there are the protocols, okay, the protocols pertaining to the courts, and then the protocol on some other economic protocols as the protocols to free movement of persons and goods and capital and various other documents.
Okay. What is the role of the ECOWAS Community Court of Justice in the protection of human rights?
The court, in its jurisdiction to protect human rights, of course, apply the rules, the protection, or rather the rules as contained in African Charter on Human and People's Rights, all the rights provided for there. And of course, we know that the African Charter on Human and People's Rights is an abstraction of the Bill of Rights. So the ECOWAS Court has done a lot in this regard, okay, in curbing the excesses of its member states and the institutions of these member states with regard to the way they treat the community members who are citizens of these member states. The citizens can now have a leeway other than the municipal courts. They can approach the Community Court of Justice when they feel that they do not have justice in their municipal court. And the beauty of it is that a matter is pending before the municipal court does not oust the jurisdiction of the Community Court of Justice. A matter pending in a municipal court, for instance, in a court in Nigeria, does not prevent the litigant from approaching, or rather an aggrieved citizen from approaching the Community Court of Justice to seek redress. So at the end of the day, you may find a litigant who has two judgments in his favor from two courts.
And it's not duplicity of what do lawyers call that? When you have the same matter in two different courts.
Abuse of court process.
Yes, abuse of court process.
No, it is not regarded as abuse of court process because the Treaty of ECOWAS empowers the Community Court of Justice to hear cases of human rights. But then it will become an abuse in the context of the ECOWAS Court of Justice when the case is pending in another international court. Other than the ECOWAS court. That is when the ECOWAS court cannot hear such a case. But insofar as it is not pending in any international court, or probably in the municipal courts, the court can still go ahead and hear it.
Oh, okay.
Yes.
Okay. So, are the judgments of the court, the Community Court of Justice, enforceable? Also, can you cite, a case, since you have a real life experience, and you tell us about the case and what the court's decision was?
In the municipal courts, enforcement is easier because after a judgment is obtained, there are rules which you can follow, and immediately you follow these rules, the police are there to enforce judgment. But then again, we cannot say that ECOWAS judgment is completely unenforceable. No, because if you have a judgment in the municipal court against the government or its institution, enforcement is not easy. For instance, in our own country, you have to still queue at the office of the Attorney General to obtain the requisite consent before you can enforce. And some persons queue and they get tired. Okay, and then but then enforcement in the ECOWAS region is even simpler, because the rules has provided that once a judgment is obtained, you can approach the registrar of the courts who will issue the writ of enforcement, and then each member country is required to appoint a national officer or a registrar, or rather institute a national institution for enforcement. And so enforcement is a matter that is purely within the registry. The litigant does not have to go the extra mile to ensure enforcement, as it is done in the municipal court, where you have to go the extra mile to ensure that the judgment is enforced. So the only problem I see at the ECOWAS region is that the sub-region, we do not have a sub-region police. But then these enforcement are done on member countries, not on individuals. And so even if we have regional police, it would have still been dicey, because you are enforcing against a government, which is distinct from enforcing against an individual.
So can you tell us about the case you handled at the Community Court of Justice?
It is a human rights case, but then the court made salient pronouncements that transcends beyond not just human rights per se, but also pronouncements that bordered on economic rights of community members and citizens. Okay. A little fact of the case: the plaintiff, Mr. Okomba, was returning to Nigeria from the Republic of Togo, where he had gone to visit his friend. At the defendant's border at Hilakoje, he was required to show his traveling documents and passport for purposes of identification. He did presented same to the police officers on duty. The officers demanded for a gratification in the sum of 300 CFA. Okay. Not complying with this demand, he was severely beaten, assaulted, severely beaten. He sustained series of injuries, and then he was detained, thrown into a shallow cell, detained for several hours, for over 5 hours, without food or water. And then in the night, he was eventually released. His passport during this period he was incarcerated in the cell was seized. Okay, and then he was released in the night to proceed with his journey. So on reaching Semeboda, he made a report of the incident. Of course, they saw him with bruises and blood, with swollen eyes and body swollen. And then the Nigerian immigration officers who were on duty could not really believe this incident, and then they took him back to make a report that same night. He proceeded on his journey. When he arrived at Abuja, he went to hospital, and then this suit was instituted around March 2014. Now, the defendant entered appearance, of course, contended the case that the incident never took place, and they merely detained him for the purposes of calming him down. Well, at the end of the trial, the court found it in favor of the plaintiff. The court made salient, prominent pronouncements in this case. On the issue of human rights, the court found it in his favor for assault. The court also found it in his favor for the temporary seizure of his documents. And then, as it pertains to his decision, the court found it in his favor also, and pronounced that the treaty regarding free movement of goods and services in Africa, in the West African region, does not contemplate detention for the purposes of calming down, and also founded that the defendant's country is in breach of their responsibility to protect rights as enshrined in the African Charter, and also respect the obligation to which they have sworn to in the Treaty of Ecowas. And so made a financial award in favor of the plaintiff.
Okay. That's quite an interesting case. So, so far, what are the challenges you're facing in enforcement? Have you commenced the process to enforce this judgment on the defendant?
Yes, we have at the moment. In the judgment, the court also made a pronouncement that costs should be assessed in favor of the plaintiff. We have written to the registrar to invite us for assessment of the cost. After that is assessed, the judgment will be served with the judgment, and I believe the defendant's country have also been served. And then the registrar will then issue the necessary writ of execution upon the number of days, about 2 months, which they have to comply of their own volition willingly. We are hoping, time is still running, they are still within time to come up and comply with this judgment, and then failing which the process of enforcement can then commence.
So, what is the significance of this case?
It's significant in 2 major ways. One, the rascality on our land borders. The land borders traversing the whole of West African sub-region has been checked tremendously by this pronouncement of the court. Prior to now, there are reports, plethora of reports, unreported reports, informal reports from citizens on how they are treated by officers who man our land borders. A lot of impunity. Okay, I, for one, when this brief came to my table, I decided for once to go through the land border to experience it myself. You are in possession of valid travel documents, everything. You cannot cross the land border without paying.
Wow.
And what betide you if you say no or you refuse to pay? Okay. Benson was one bold West African citizen who stood his ground and said, I do not have money to pay. And not having money to pay does not impede on my right as a free citizen of Ecowas to move around. And he stood his ground. Though he got the beating of a lifetime, today the authorities of that country are well aware that there is a check on impunity on our land borders. With this fine, I think investigation, and when reports are made, countries can now take investigation seriously, timelessly, and prevent this. And it is also salient, secondly, that's the second one. Secondly, the Community Court of Justice solved the problems ordinarily the litigant would have encountered if there were no central forum as provided, just like the Community Court of Justice. For instance, if you were to go to the Republic of Benin to seek redress for this abuse, number one, language barrier, cost. Okay, another problem that you have encountered, and then this right will go unchecked. This impunity will go unchecked. These rights, these abuses will continue, and then at the end of the day, it's going to affect tremendously cohabitation in the sub-region. Okay, the court provided a forum where the citizens can ventilate their anger, provided a common forum where the problem of language, the issue of language barrier was checked. And so we were able to present our case, even though it is now the meeting point between common law region and civil law region. But the court provided a common forum for all to be heard. And at the end of the day, we believe that this is a tremendous improvement towards economic growth and development, because citizens now know that they can move around, not just through the air, through the land, through the sea, and then they are protected whichever means of movement they prefer.
Okay, thank you so much for this wonderful insight on the Community Court of Justice. I really appreciate your presence on Judiciary Watch today.
Thank you so much. It is my pleasure. Okay. Indeed.
You just watch Judiciary Watch.
Because there's no program that is like it.
where we say goodbye on today's episode of Judiciary Watch. We will appreciate all your comments and contributions on our email and social media platforms. Don't forget to be conscious of your rights and be law-abiding. Goodbye.